Let's now understand and start with a new topic, which is about company directors. So, who are directors? Who is a director? Wherein we'll understand the definition of director, what are the different types of director, how appointment of director happens, what are the situations wherein a director is disqualified, how removal of director happens, what are the duties and powers of directors. So before we start, let's understand a few basics about company directors. Director is basically a person who is responsible for the overall management of the affairs of the company, for overall directions of the company. So how a company works, what are the different decisions which are being taken in the company. It is the directors who are responsible for the management. All the members, they cannot come and take decisions. And that is the reason why directors are appointed in a company, and these are the people who take care of how things are happening in the company and how the management of the company shall happen. So directors are the people who are responsible for taking the decisions for the day-to-day management of the company and also for the important transactions which are being made in the company. So it is the directors who are responsible for all of it. Now, when we talk of directors, there are different types of directors which are in place. But before we talk of the different type of directors, let's understand the definition of directors. So the term director includes any person occupying the position of director by whatever name called. So the definition is very simple. It says any person who is occupying the position of the director is a director. It includes any person who is occupying the position of the director. And whether to decide whether a person is a director or not, we do not look at the title. There may be some employees in the company who have been given the designation of a director, but their functions are not that of a director of the company. They are not a part of the board of the directors. So, in order to decide whether a person is a director or not, we'll have to look at their functions. What are the different functions they are performing in the company, and not only at their designation and not only at their title. And a director has to be a natural person only, which means a body corporate cannot become a director or cannot be appointed as a director, and must normally be aged at least 16, which means the minimum age prescribed is 16 years. You should be at least 16 years old to be appointed as a director in a company. And all the directors of the company, they shall be natural persons only. Artificial persons, they cannot be appointed as directors. Only natural persons. And who are natural persons? Human beings. So human beings are only capable of being appointed as directors in a company. So let's talk of the different type of directors now. So the first one is de jure director. Now, what does it mean? This is a person who has been appointed, properly appointed or legally appointed as a director in the company, and who has also given his consent to hold the office of the director. So a person who is formally and legally appointed or elected as director in accordance with the articles of association of the company and gives written consent to hold the office of the director is a de jure director. So basically, a director who has been properly appointed, who has been appointed or elected as the director in the company according to the articles of association of the company, and this person was also, and he has also given his written consent to become a director. That type of a director is a de jure director. Now, when we talk of another type of director, the other type of director is a de facto director. Now, de facto director is basically a person who is not actually a director. Under de jure director, we have understood that this is a person who is being appointed in accordance with the AOA, and he has also given his consent. But when we talk of de facto director, this is a person who is not a de jure director. Basically, has not been appointed as a director, but he gives instructions or he gives directions to the other directors and employees in the company, and they act according to his directions. Now, say for example, so this is a hypothetical situation. Say for example, say Mr. Mukesh Ambani, he is a managing director of Reliance, but let's assume a situation wherein, say, Mr. Ambani, he's not a director in Reliance, but he is a maximum shareholder. Now, though he is not a director, but he gives instructions and directions to the other directors and the employees of the company, and they act according to his instructions. So, in that situation, Mr. Ambani will become a de facto director. So, de facto director is basically a person who is not actually appointed as a director, but in accordance with whose instructions and directions the other directors or the employees of the company act. So, a de facto director is a person who is not a de jure director but performs the acts and duties of a director. So, he's not a de jure director, but he performs the acts and duties of a director. So, he's not technically a director, but in accordance with whose instructions and directions the other directors and employees of the company they are accustomed to act. So, he is deemed to be a de facto director. And the de facto director owes the same duties to the company as a de jure director. So they have their own duties, whatever duties a de facto director does, de jure director does, the similar duties are performed by a de facto director as well. So he's not legally appointed as a director, but he's deemed to be a director of the company. So that type of a person is a de facto director. Let's now talk about the different types of directors. So the first one here is a managing director. So managing director is basically the director of the company who takes care of management of the day-to-day activities, day-to-day affairs of the company. So he's the person who's taking care of the overall day-to-day management of the company. That type of a director is called as a managing director. Now, apart from managing director, there's another type of director, which is a shadow director. So shadow director is quite similar to a de facto director. So he's a director in accordance with whose instructions or directions the company is accustomed to act. And it is similar to a de facto director only. So all the rules of company law, they are applicable to a shadow director also. And he is a person who is giving advice and who is giving instructions to the directors or the employees of the company. However, if a person is giving advice in a professional capacity, if a person is giving advice in a professional capacity, say, for example, a lawyer or an advocate, a lawyer is giving advice to the company, and in accordance with the lawyer's instructions, the company is acting. So, in such a situation, that person, in accordance with whose instructions the company is acting, will not deem that person as a shadow director just because he is giving some instructions and the company is acting on the instruction doesn't make a person a director. So if a person is acting in a professional capacity, he is not a director. The next type is an executive director. So an executive director is basically a full-time employee of the company. He comes to the company every day, performs day-to-day activities, and he's well aware of what is happening in the company and what is not happening in the company. And finally, the last type is a non-executive director. So non-executive director is basically a person who does not take part in the day-to-day activity of the company, but rather he is a part of the board. He is a director who has been appointed for his expertise. Okay, so this person, he is appointed for his expertise. He does take part in the meetings of the company. He comes whenever there's a meeting in the company, and they come and give their expert opinion on different decisions which are to be made in the company. Okay, so when we talk of executive director is a full-time employee, whereas When we talk of a non-executive director is not a full-time employee of the company. Rather, a non-executive director is a director who is independent and who comes to the company to give his expert opinion. So these are the different type of directors in a company. So the first type is a managing director or a CEO, or so he's a director who is appointed to carry out the overall day-to-day management functions. So the model articles allow the board to delegate to MD or CEO any powers they see fit. They have dual role, member of board and also executive officer. So MD and CEO, they basically take care of the overall day-to-day management functions of the company, and the powers which have been specified, the powers would be delegated to them by the board, and they play a dual role of both the member of the board and also executive directors. Now, talking of shadow director. So, a person in accordance with whose directions or instructions the directors of the company are accustomed to act. So, this is nothing but a de facto director. So, they are used to regulate activity by those who exercise control over the company or try to evade their responsibilities and potential liabilities as a director. So, all rules of company law are equally liable to shadow director. So if advice is given in professional capacity, then that person is not a shadow director. Executive director, they are full-time employee who are involved in the management of the company. They perform specific role under a service contract, may be distinguished by a special title such as sales director or finance director. So executive directors, they are full-time employee of the company, and they may be given some specific titles as well, such as sales director or finance director, which specify what is the scope of their work. Now, talking about non-executive director, so they are part-time, they are not an employee, brings outside expertise to the board. So like we've understood, they are basically a part of the board because they have expertise in a certain field. They contribute their independent view, exerts control over executive director, and subject to same duties, controls, and potential liabilities as executive directors. So non-executive directors are basically people who are a part of the board because of their expert knowledge in a particular field. So they are non-executive directors. So with this, we've now understood what are the different types of directors. Apart from it, there's also a chairman of the board who is appointed. Chairman of board is basically who chairs the board meeting, and he's the spokesman of the company, and he has a casting vote. Casting vote basically means in case there's equality of votes in the meeting, then the chairman has a second vote, which is called as a casting vote, which will be the deciding vote. And in certain situations, alternate directors can also be appointed by a director who can attend and vote on behalf of this director in the board meeting. So say for example, a person, he's a director in the company, but he knows that he will not be able to attend the meeting of the company. So he appoints another person in his place who will go attend the meeting and vote at the meeting on his behalf. So that type of director is an alternate director. Now, when we talk of directors, a person has to be first expressly appointed as a director, and only then he can carry out his functions as a director. So a person cannot act as a director without being actually appointed as a director. First, appointment has to be done, and only after a person has been appointed as a director, he can carry out his functions as a director in the company. So, whenever a company is being incorporated or whenever a company is registered, application has to be made with the registrar. So in that application also states the details of the first directors of the company along with their consent. So whenever a person is being appointed as a director in the company, obtaining his consent is mandatory. A person who is being appointed as a director, his consent is required. Now, and whenever an application for registration of company is made, the application, it contains details of the first directors. And once the company is formed, those persons, they are the first directors of the company. First directors, the name itself suggests, because they are the directors when the company has been formed. So for a newly incorporated company, they are the people who will be the first directors of the company, and that is why we call them as first directors. Now, talking of how many directors to be appointed, in case it is a public company, minimum number of directors is 2. In case it is a private company, then the minimum number of directors is 1. There is no maximum limit specified statutorily. However, the articles of association of the company, they may specify a maximum number. So the law does not specify any maximum limit. However, there can be a maximum limit specified by the articles of the company. Talking of how the appointment of directors is made, so the directors, they are usually appointed by the existing directors, or by the shareholders by passing by passing an ordinary resolution or any other manner which has been specified in the articles of the company. So once the directors have been appointed, there can either be replacement of directors, or there can be addition of the directors. And whatever is happening, the appointment of directors should be by passing an ordinary resolution of the shareholders, and also by the decision of directors of the company. As soon as there's any change in the directors of the company, every company, they should inform about this change within 14 days to the registrar. So within 14 days of such change, the registrar has to be informed about the change in the directors of the company. So first directors, public company needs a minimum of 2, private company needs 1. No maximum limit specified statutorily, but articles may specify a maximum number. So the law does not specify any maximum limit. However, the articles can specify a maximum number. What is the appointment procedure? Appointed by existing directors or by ordinary resolution. Directors of public companies should be generally voted on individually. The director's actions are valid notwithstanding their appointment was defective. So even if the appointment of director did not happen properly, it was defective, the actions of the director will still be valid. Now, what happens at the first AGM of companies? So at the first AGM, all the directors retire and offer themselves for re-election by ordinary resolution. So on the first AGM of the company, all the directors, all the existing directors, they retire and they offer themselves for re-election. That is, they can be reappointed as director in the company. And at every subsequent AGM, 1/3 directors retire and they can be re-elected. So on the first AGM, all the directors retire and offer for re-election. However, at every other AGM, 1/3 directors retire, 1/3. These would be the most senior ones. So 1/3 directors retire and they can also be re-elected in the same AGM itself. And these casual vacancies are filled by board until the next AGM, when the new directors must stand for election. So whenever a director is retiring, there's a vacancy in the director's office. So this vacancy shall be filled by the board till the next AGM. And the company must notify Companies House. Companies House is nothing but the registrar within 14 days of new appointments, in case any new director has been appointed or any changes in the director, and it must also enter the details in the register of directors. So within 14 days, this information has to be intimated to the registrar about whenever there's any change in the director, or whenever there's a new person who has been appointed as the director of the company. Now, talking of age limit, minimum age is 16 and there's no upper age limit which has been specified. And the directors, they are entitled to receive remuneration. And whenever a director is appointed, there's a service contract which is made, and according to whatever has been stated in the service contract, the director will be remunerated. And the term of service contract is generally 2 years, cannot exceed 2 years. However, if a service contract exceeding 2 years is being made, then it can be made by an ordinary resolution. So for making a service contract exceeding 2 years, an ordinary resolution by the shareholders is required. So service contracts, they cannot exceed 2 years unless approved by ordinary resolution, which means if it is approved by the ordinary resolution, the term of service contracts can exceed 2 years as well. If Section 188 is breached, the service contract is deemed to state that the company can terminate the contract at any time by giving a reasonable notice. So, in case of any breach, the service contract also can be terminated by the company by giving a reasonable notice to the director. So, breach of service contract will lead to termination of service contract as well. And the service contract must be kept open for inspection at the company's registered office. The service contract which is made, it shall be kept open for inspection at the registered office of the company. The directors of a quoted company must prepare a director's remuneration report for each financial year of the company. So the directors of a quoted company, they are required to prepare a director's remuneration report, which will form part of the annual report, and it shall be prepared every financial year. And the report will contain for each of the person who is a director during the year, what are the different things the report would contain. Let's see. It will contain the date of the contract, the unexpired term, and the details of notice period, any provision for compensation payable upon early termination of contract, and details of other provisions in the contract as are necessary to enable members of the company to estimate the liability of the company in event of early termination of the contract. So this director's remuneration report, it shall state all these details. What is the date of the contract? What is the period of the contract? What is the unexpired term? What are the notice periods required? And if any compensation has to be payable in case there's an early termination. Apart from it, any other details which are necessary for the members to estimate the liability of the company, liability which may devolve upon the company in case there's any early termination of the contract which is made. And gratuitous payments must be disclosed to all the members and approved by ordinary resolution. Not approved, director holds payments on trust of the company. So in case there is any loss of office of the director, so in that situation, compensation has to be paid to the director for loss of office. And this compensation which is payable for the loss of office, it shall be approved by the members of the company in the general meeting by passing an ordinary resolution. Let's now talk about disqualification of directors. Now, disqualification basically means if a person is disqualified, basically he is not qualified to become a director in a company. So, a person cannot be appointed as a director or continue in the office of director if they become disqualified under the articles or under the statutory provisions. So, if a person has become disqualified, he's no longer eligible to be appointed as a director and also to continue as a director in that company. So, what are the different situations where we say that a director is disqualified? So, this disqualification of directors is divided into two categories. So, disqualification of directors is divided into two categories. One is under the model articles, and the other is under statute. So, what are the situations specified under the model articles where a director would be disqualified? Let's understand. So the model articles, they include a number of grounds for disqualification of director. They include cases where the director, he ceases to be a director because of the provisions of the act, or say when a person is declared bankrupt. If a person is declared bankrupt, he'll be disqualified from acting as a director. So if a bankruptcy order is made against a person, he is disqualified by the model articles. Apart from it, the next situation is wherein, say, a registered medical practitioner, he has given in writing that this person is incapable or has become physically or mentally incapable to perform such duties. So if a registered medical practitioner has given his opinion in writing that this person is physically or mentally incapable of acting as director and may remain so for a time span more than 3 months, then in that situation again the director would be disqualified. Or say wherein the director is himself resigning from his office where say a person is disqualified under the Companies Act. So these are the different situations where a person would be disqualified from acting as a director. Now talking of under statute, say a person, if he has committed some offense or has been convicted of an offense in relation to formation or promotion or management of the company, then he is disqualified. Or say wherein there is a persistent default in relation to the company related provisions, in that situation as well the person would be disqualified. And there are different periods. If a person has acted fraudulently or has been found guilty of fraudulently trading, in that situation again he'll be disqualified. So there are different situations wherein a person would be disqualified by law from by the statute to act as a director. So let's have a look at the disqualifications of directors. So the directors must vacate their office if they become bankrupt. So as per model articles, we have understood that if a person has become bankrupt, then he cannot continue as a director. He has to vacate his office. Now, what are the other situations wherein a person would be disqualified? So there are distinct categories of conduct. So first one is general misconduct in connection with companies. So if a person is convicted of a serious offense in connection with the management of company, either in UK or abroad. So if a person has been convicted of a serious offense which is in relation to management of the company, either in United Kingdom or any other country, then maximum 15 years disqualification. Then the person would be disqualified and the maximum term of disqualification would be 15 years. Then the second situation is persistent breaches of Companies Act. In that situation, the maximum disqualification period is 5 years. So the first situation was conviction of serious offense of mismanagement or in connection with management of the company. Then a maximum time period of disqualification was 15 years. Second situation is continuous breach. Persistent breaches means continuous breaches of the Companies Act. The maximum term of disqualification is 5 years. Disqualification for unfitness. Now, what unfitness means? So, when an investigation by the Department of for Business, Energy and Industrial Strategy finds the director unfit to be concerned in the management of the company. So, if this department, upon investigation, they find out that a director is unfit to be concerned in the management of the company, he is not proper, he is not fit to become a part in the management of the company, then that person is disqualified. So, where a liquidator's report finds the director unfit to be concerned in management, minimum 2 years disqualification, maximum 15 years disqualification. Where the liquidator's report finds that the director is unfit, disqualification is of minimum 2 years, maximum 15 years. Other cases of disqualification are where a person participates in fraudulent or wrongful trading, maximum 15 years. Where an undischarged bankrupt has been acting as a director, where a person acts on behalf of any disqualified directors. These are also grounds of disqualification of a person to act as a director in a company. Now, if the disqualification order is breached, then this is a criminal offense which could result in fine and imprisonment. Breach of disqualification order is a criminal offense and it could lead to fine and imprisonment. And the disqualified director is personally liable for debts of company while doing so. So if he breaches, he is disqualified but continues to act as the director of the company, enters certain transactions, then in such a situation, that disqualified director will become personally liable for the acts of the company while for the transactions which he has entered into. So with this, we've now understood who is a director, what are the different types of directors who are appointed in a company, what is the process of appointment of director in a company, and also what are the situations wherein a person is disqualified from being appointed as a director. So we've understood all these situations. So this was with respect to companies directors in brief, wherein we've understood who is a director, about the appointment of director, and also about the disqualification of directors.
Hey, are you considering ACCA as a career path? Then you're at the right place. Call us at 9640 or log into indigolearn.com or download our app OneFin by Indigolearn.